Committee on the Judiciary, Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. Without objection, the Chair is authorized to declare recesses of the subcommittee at any time. Welcome to today's hearing on enhancing the Foreign Agents Registration Act of 1938. Remind members we have an email address. Want to have exhibits, motions, etc. Our hearing today. If you'd like to submit those materials, send them to the address there, and we will distribute them. Finally, I'd ask all members of witnesses to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. Obviously, you may unmute yourself anytime you seek recognition. Otherwise, you will not be able to gain recognition. I'll recognize myself for an opening statement. At an historical moment when America once again finds itself in a global struggle against anti-democratic adversaries abroad, it is right that the subcommittee examine one of the tools that Congress intended to protect us from undue influence in our nation's policy-making process, the Foreign Agents Registration Act of 1938. Congress passed and President Franklin Roosevelt signed FARA, as it's known, into law in response to concern about Nazi Germany's efforts to spread propaganda and influence political discourse in the United States in the years leading up to the Second World War. So Russia's not unique in this. They're much like the Nazi Germany. Congress later amended the statute in the 1960s and the 1990s to confront new circumstances. Indeed, the last time any component of the House Judiciary Committee held a hearing specifically focused on FARA was in 1991. Under FARA, an agent of a foreign principal that is engaged in certain activities on behalf of that country within the United States, such as political activities, acting as an information service, or representing interest before any U.S. government agency or official, must file a registration statement with the Department of Justice within 10 days of becoming an agent and file supplements detailing their activities with the Department of Justice every 6 months. Registrants are also required to disclose copies of informational materials that the registrant believes will be or intend to be disseminated or circulated among 2 or more persons on the foreign principal's behalf. Registrants also must label those materials to indicate they are being disseminated by an agent or of a foreign principal, and to keep records of the registrant's activities for 3 years following the end of their agent status. FARA defines the terms agent of a foreign principal and foreign principal very broadly. For example, foreign principal means not just foreign government or foreign political party, but includes any person outside the United States, unless the person is a U.S. citizen or an entity organized under U.S. law that has its principal places of business in the U.S. Is it FARA or FARA? Finally, FARA contains a number of exemptions, including one for those who are registered under the Lobbying Disclosure Act, or the LDA. In connection with the agent's representation of foreign principals is not a foreign government or a political party. For decades, the Department of Justice has initiated few FARA enforcement actions, pursuing only a handful of prosecutions under the Act's criminal provisions and a few attempts at seeking injunctive relief, the only civil remedy currently available under the Act. Since 2017, the Department of Justice has admirably increased the resources and attentions devoted to enforcing this law, including hiring additional staff dedicated to civil enforcement. The result has been a 50% increase in registrations today compared to 2016. Some high-profile FARA-related charges included those against former Trump campaign manager Paul Manafort for failing to register under FARA for his work in representing former Ukrainian president and Soviet Russian friend Viktor Yanukovych, and Ukraine's pro-Russian Party of Regions as well as charges against former National Security Advisor Michael Flynn for making materially false statements on documents that he filed pursuant to FARA for his work in representing the Turkish government. While the Department of Justice has increased efforts at FARA enforcement have clearly reinvigorated the Act, there remains areas where the Act itself could be strengthened and better targeted. I note also the Department is currently engaged in the preliminary stages of a FARA-related rulemaking process. Since 2016, many members of Congress have introduced FARA-related measures focused mostly on enhancing enforcement. Our own distinguished subcommittee ranking member and outstanding servant to his community, for which he got a great deal of money recently, Mike Johnson, the ranking member, has sponsored a bill a few years ago that contained some ideas that we might be able to support. The subcommittee should consider enforcement enhancement measures like eliminating or curtailing FARA's Lda Exemption, the lobbyist exemption, providing for civil penalties to encourage more civil enforcement by the Department of Justice and updated standards for making firearm materials publicly available. H.R. 1, the For People Act of 2021, which passed the House, amends FARA to provide civil penalties and additional resources to the Department of Justice to enforce the act, among many other portions of the law. Importantly, FARA is a transparency measure. It cannot constitutionally prohibit speech, even by foreign principals, and shouldn't. In taking this balanced approach, Congress recognized that in meeting our desire to confront foreign influence in our political process, we should not erode our own constitutional values. But registration and notice is okay. Transparency. In keeping with this loyalty to our own values as we seek to enhance FARA, we should keep in mind some potential unintended consequence of stronger enforcement and ask whether sharper targeting of FARA may be necessary to achieve the Act's aims without compromising our civil liberties or diverting attention away from FARA's primary concerns. Thank our witnesses for being here. I look forward to their testimony, and I'd now like to recognize the distinguished ranking member from the city of Shreveport, home of the Independence Bowl, Mr. Johnson, for his opening statement.
Thank you for that, Mr. Chairman. I do want to thank our witnesses for being here this morning. The Foreign Agents Registration Act, or FARA, for folks watching at home, as mentioned, is a decades-old law that has been pushed to the forefront of politics in the courts in recent years. The point of FARA is simple. If you engage in certain activities on behalf of a foreign principal, you are supposed to register with the Department of Justice. The purpose of this law is very simple. We need to inform the American public when people working for foreign companies or governments intend to influence our government, the U.S. government officials or the American people. It's a very important statute that ensures transparency in our system, and as such, violations of FARA carry stiff penalties, up to $250,000 fine for each violation and up to 5 years in prison. For decades, FARA was only known to D.C. insiders. Really, the Department of Justice focused on promoting voluntary compliance with the law rather than prosecuting violations. One Washington, D.C. lawyer who represents clients in FARA matters remarked that before 2016, FARA was, quote, a backwater of American law, and a very still backwater at that, with just 7 prosecutions between the years 1966 and 2016, just 7 cases. But that all changed after 2016, and a lot of people scratch their heads and wonder why. Well, desperate to find any law that President Trump and his aides could have broken during the 2016 election, Special Counsel Robert Mueller and his team turned to FARA. They dusted it off, and he and politically biased FBI officials sought to push FARA to its limits. Why? To advance their partisan investigations and take down anybody related to President Trump. The FBI used failing to register under FARA during investigations to pressure George Papadopoulos, Michael Flynn, Paul Manafort, and Carter Page. On April 28, 2020, the FBI and the DOJ even used a failure to register under FARA to justify a raid on Rudy Giuliani's apartment and his law offices in New York City. Of course, now that President Trump has left office, the FBI again has little interest in enforcing FARA. If that's not evidence of political bias in the depths of government, I don't know what is. Especially since there is ample evidence now that during the Obama administration, listen to this, hey, everybody turn on the news, Hunter Biden attempted to influence his father, then Vice President Joe Biden, by promoting the interests of foreign companies, full stop. This evidence can be found in Hunter Biden's laptop, which we now know the FBI has had in its possession since December 2019, nearly 2.5 years, but has seemingly done nothing with it at all. My colleague, Congressman Matt Gaetz, also introduced the laptop into the congressional record of the House Judiciary Committee, this committee, just last week. And I certainly hope the majority staff doesn't delay the sharing of its contents with the American people. Everybody has a right to know that the son of the vice president used his political influence to benefit, among many other companies, CEFC, China Energy Company, a Chinese conglomerate whose chairman had links to the Chinese Communist Party. And it wasn't as if Hunter had no idea he was potentially breaking the law over his dealings with a Chinese corporation. Listen to this. On May 1st, 2017, he texted his friend and business associate, Tony Bobulinski, writing, quote, "We don't want to have to register as foreign agents," unquote. He goes on to suggest that they set up a shell corporation to presumably shield their involvement and allow the Chinese company to do business with the U.S. government without raising flags. Mr. Bobulinski has since publicly stated that then Vice President Joe Biden knew exactly what Hunter's business dealings with China were as he discussed them with him directly. An email from Hunter's laptop dated May 13, 2017 even contains a discussion of, quote, remuneration packages for a deal with CEFC China Energy Company, including equity splits of, quote, 20 for H and, quote, 10 held for H for the big guy. According to Bob Linsky, the big guy is a nickname Hunter commonly used to refer to his father. The laptop also has evidence of possible FARA violations from Hunter Biden's involvements in Ukraine, Kazakhstan, and Sri Lanka, just to name a few. In summation, Hunter Biden appears to have arranged meetings with U.S. officials and engaged in other representational activities on behalf of his foreign business connections. Based on my reading of FARA, and anybody else who looks this up, failing to register such behavior is clearly a violation of the law. However, the DOJ and FBI have so far failed to utilize the same hardball tactics they used against President Trump's aides to get answers from the current president's son. To date, 0 charges have been filed, and FARA has not been used as a pretext to conduct any pre-dawn raid of Hunter Biden's residence, as was done to Mr. Giuliani. Once again, the political bias of our country's top law enforcement bodies is rearing its head. The double standard continues to erode the American people's faith in our institutions, and this is a dangerous road to be on. Mr. Chairman, I look forward to further discussing this issue with our witnesses today, and I yield back.
Thank you, Mr. Johnson. I would just mention that they also prosecuted Mr. Greg Craig, who was a favorite on the Democratic side. And I want you to know, because of your testimony, I've instructed Mr. Greengrass to get us the computer as soon as but after he gets us the unredacted Mueller report, the final information on the Kennedy assassination, and as much as he can get on the death of Marilyn Monroe.
Listen, with respect, Mr. Chairman, you can mock that, but this has been duly entered into the record of this committee. There is no reason to delay it, and the American people are demanding to know the contents of that laptop. And I think this committee has an obligation under the law and the rules of the committee to get that done.
I agree with you. We're going to get those other 3 things, too. Mr. Nadler, you're recognized.
Thank you, Mr. Chairman. And I, too, wish to thank our witnesses for appearing today. Today's hearing on the Foreign Agents Registration Act of 1938, often referred to by its acronym FARA, is an important opportunity for members to learn about the origins and development of the Act and to consider potential enhancements. Although FARA has been on the books for decades, the statute remains relatively obscure to members and the public. As Chairman Cohen noted, it has been over 30 years since the House Judiciary Committee last held a hearing on FARA. Then Representative Dan Glickman, who was invited to testify at that hearing, remarked at the time that FARA is, quote, either widely misunderstood, ignored, poorly written, not enforced, or all of the above, unquote. While I would add that FARA is an important tool for government transparency and would note that the Justice Department has taken steps to improve enforcement of the Act in recent years, the gist of Representative Glickman's statement arguably still applies today. Passed by Congress in 1938 to combat the influence of Nazi propaganda, FARA is a public disclosure law that generally requires an agent of a foreign principal, in quotes, engaged in certain covered activities on behalf of a foreign principal to register with the Department of Justice. In the 1960s, Congress amended FARA to reorient the statute away from exposing sources of foreign propaganda towards concerns regarding efforts by foreign interests to influence U.S. policy through lobbying. For decades, however, FARA went relatively under-enforced by the Justice Department. A 2016 Office of Inspector General report noted that the department brought only 7 criminal FARA cases between 1966 and 2015. The Justice Department has recently stepped up FARA enforcement since the 2016 presidential election and the special counsel's prosecution of several individuals, including former Trump campaign manager Paul Manafort and former National Security Advisor Michael Flynn, for charges related to FARA violations stemming from political activities they engaged in on behalf of foreign governments. This increased enforcement appears to have had an effect. According to one Justice Department official's post to the website Just Security, the number of FARA registrants has increased by 50% since 2016. This past December, the department also published an advance notice of proposed rulemaking seeking public comment on potential changes to modernize FARA's implementing regulations, including clarifying the scope of certain exemptions and updating various definitions. I applaud the Justice Department's recent efforts to increase FARA enforcement. At a time when we see democracy literally under Russian attack abroad in Ukraine, and foreign government attempts to influence or undermine the democracy at home, it is important to shine a light on efforts by foreign governments to shape U.S. policymaking. But I also think it is important to keep in mind, as we consider proposals to enhance FARA's transparency mechanisms, that while hidden efforts by foreign governments to influence U.S. policymaking and the public have a corrupting effect on our democracy, the underlying activities FARA regulates are constitutionally protected. That is why Congress, even as war clouds began to gather over Europe in the 1930s, chose transparency as the means to combat foreign influence in our democracy. It is also why I am opposed to proposals to grant the Justice Department the authority to issue civil investigative demands, also known as CIDs, in the FARA context. My fear is that such type of administrative subpoena authority, which by definition lacks judicial involvement, may be used as an end run around Fourth Amendment protections and potentially erode other constitutional rights. While CID authority always raises civil liberties concerns, this authority is particularly troubling in the FARA context because the statute regulates constitutionally protected activities. Moreover, because FARA lacks robust civil penalties, most recent FARA proceedings have been criminal in nature. As of the publication of the 2016 OIG report, the Department had not sought civil injunctive relief under FARA since 1991. These factors, which are particular to the FARA context taken together, heighten the risk that granting CID authority will erode civil liberties over time. Indeed, as we will hear from one of our witnesses today, as it is, nonprofit organizations across the political spectrum have raised concerns with FARA's sweeping scope, which may create unintended consequences and burden constitutionally protected activities Congress arguably sought to exempt from the statute, and it may permit future administrations too much discretion to use FARA's breadth to selectively investigate or prosecute organizations whose viewpoints the government disfavors. Any discussion of how to enhance FARA's enforcement and public transparency mechanisms would not be complete without also considering the potential consequences and concerns raised by the nonprofit sector. Lastly, I would like to express my desire for today's discussion to remain focused on legal and policy considerations. We have already heard from members who they think should be investigated for FARA violations. We are not here today to discuss the details of any potential case or individual. Instead, it is my hope that, amidst the potential temptation to score partisan political points, it is not lost on us that there appears to be general bipartisan support for FARA and that there may be areas of bipartisan agreement on how to improve the Act. I look forward to hearing from our witnesses on potential avenues for reform. With that, I thank Chairman Cohen for holding a hearing on this important subject, and I yield back the balance of my time.
Thank you, Mr. Nadler. I now recognize the ranking member of the committee, Mr. Jordan from Ohio, for much time as he shall consume.
Thank you, Mr. Chairman. On October 22nd, 2020, just 2 weeks before the most important election we have, election for President of the United States, then candidate Biden said regarding his son's dealings with foreign companies, quote, "Nothing was unethical. My son has not made money from Chinese business interests." Now, there are 4.8 million reasons why that statement was not accurate. And how do we know? How do we know that statement was not accurate? The Washington Post told us so last week. Not Mike Johnson, not President Trump, not Republicans. The Washington Post told us this last week. They did 2 stories last Wednesday, one at 11 a.m., one at 11:04 a.m. 2 8-page stories, 4 minutes apart, confirming what we already knew. The laptop was real, the eyewitness was real, the emails were real. The only thing fake 18 months ago in the run-up to the presidential election was the news. I find that amazing. 2 8-page stories, 4 minutes apart, saying the laptop is accurate, all the emails are accurate, saying this from the Washington Post, when for 18 months they said, no, it was Russian disinformation. I mean, think about what happened in the run-up to the most important election we have. Big media, big tech, and Democrats all colluded to bury that story. Something I think the American people would have liked to have known a little something about as they went to the polls to elect the commander-in-chief. And they were joined, it wasn't just big tech, big media, and Democrats telling us something that wasn't true. They were joined by 51 former intelligence officials who told us it was Russian disinformation. Now think about this. This is funny how the story has changed. First, it wasn't his laptop. Then it was, oh yeah, it was his laptop, but it was Russian disinformation. Then it was, no, it wasn't Russian disinformation, but Joe Biden wasn't involved. And now it was, oh yeah, Joe was involved, but he did nothing wrong. Amazing how that's all changed in 18 months. So I look forward to hearing from our witnesses and figuring out what we can do with the Foreign Agent Registration Act of 1938. Probably does need some changes, something done to it. But the title of today's hearing is Enhancing FARA, the Foreign Agents Registration Act of 1938. How about we just figure out a way to apply it consistently? As the ranking member said in his opening statements, this has been used just about anyone who was involved in the Trump campaign had it used against them to get information and do a prosecution, do the whole Mueller investigation, which found out there was no collusion. We obviously had collusion here. Maybe it does need to be applied, at least in a consistent fashion, to Hunter Biden. We know Hunter Biden took millions of dollars from the wife of the mayor of Moscow. We know he took millions of dollars from energy companies in Ukraine and millions of dollars from companies in China with ties to the Chinese Communist Party, including, as the ranking member mentioned, CEFC, which paid him $4.8 million in 1 year's time. Should Hunter Biden have registered under this act? Why didn't he register under this act? Why is the Department of Justice being inconsistent? At least that's what it seems. When, as the ranking member said, only 7 people were prosecuted between 1966 and 2016, and then, shazam, they started using it against everyone associated with President Trump's campaign, it seemed. So this is important. The chairman of the committee just said, we're not here today to discuss individuals. But I do think the American people would like to know the truth about this story and why it was kept from them, kept from we the people, prior to, as I said before, the most important election we have in this nation. That's important information, and I hope we can begin to dig into that. This committee should dig into that. We should be all about making sure the American people get the truth and not have, as I said before, big tech, big media, Democrats, and 51 former Intel officials tell us something in the run-up to the election that was not accurate. With that, I yield back.
Thank you, Mr. Jordan. Our witnesses are here. We welcome you and thank you for participating. Introduce each of the witnesses before their testimony. Therefore, you might remember who they are. You get 5 minutes. There's a light system in front of you. Green means you're on, and you get somewhere between 1 and 4 minutes. Then it turns yellow, and that means you're down to your last minute. And when it turns red, that means you should be finished. Your full testimony will be entered into the record, although 5 minutes is what you're limited to in testimonial. I'll give verbal notice on the minutes remaining today as well. Before proceeding with the testimony, I'd like to remind all of our witnesses that you're under oath to tell the truth, and if you don't, you could be cited with a violation of Section 1001 of Title 18 of the U.S. Code. Our first witness is Mr. Jacob Strauss. Doctor, it says there. I guess he is a doctor. He's a specialist on the Congress and the Government and Finance Division of the Congressional Research Service, which is one of our most esteemed branches. He works on lobbying, ethics, commemorations, including monuments and memorials, and congressional advisory commissions. Dr. Strauss received his MA and PhD in political science from the University of Florida and his BA from the University of Maryland. Dr. Strauss, you're recognized for 5 minutes.
Chairman Cohen, Ranking Member Johnson, and members of the subcommittee, on behalf of the Congressional Research Service, thank you for the opportunity to appear today. My testimony focuses on 2 areas: the history of the Foreign Agents Registration Act, or FARA, and legislative proposals to amend the law. Concern over foreign influence in American politics dates to the Revolutionary War and the Continental Congress's alliance with France. President George Washington addressed foreign influence in his 1796 farewell address, writing that, quote, "History and experience prove that foreign influence is one of the most baneful foes of Republican government." In the early days of the Republic, several incidents brought concerns about foreign influence to prominence. In 1808, for example, the House of Representatives authorized an investigation into allegations that General of the Army James Wilkinson was a Spanish agent. General Wilkinson was ultimately acquitted, but governmental interest in the potential influence of foreign governments and actors on American public policy remained for much of the next century. The idea of regulating foreign influence dates to at least the early 1900s, when the first pieces of legislation aimed at directly addressing the real or perceived possibility of foreign influence in American politics were introduced. These measures generally would have required the registration of individuals or groups seeking to influence public policy or promote propaganda. With the rise of Nazism in 1930s Germany, concern about foreign propaganda and influence grew. In 1934, the House created the Special Committee on Un-American Activities to investigate foreign propaganda and influence. Chaired by future Speaker of the House John McCormack, the Special Committee investigated the scope of foreign influence activities in the United States and the spread of subversive propaganda that originated from foreign countries. In 1937, Representative McCormack introduced the bill that would become FARA, and on June 8, 1938, President Franklin D. Roosevelt signed it into law. As enacted, FARA sought, as described by the Department of Justice, to, quote, "combat the spread of hidden foreign influence in American politics." Specifically, FARA responded to foreign influence concerns by creating a system designed to identify agents of foreign principals who might engage in subversive acts or in spreading foreign propaganda, and to require them to make public record of the nature of their employment. Over the years, Congress has substantially amended FARA on several occasions, most notably in 1942, 1966, and in 1995. Today, the Department of Justice administers FARA. The law, as amended, generally focuses on individuals conducting advocacy or public relations work on behalf of foreign principals within the United States. These agents of a foreign principal are required to register with DOJ and provide information about their business and foreign principals they represent. For each foreign principal, a foreign agent must periodically disclose to DOJ copies of contracts, details of the financial relationship, advocacy and public relations activities, and informational materials. In recent years, various members of Congress have introduced a number of measures to amend FARA. A CRS review of these bills identified several trends. Broadly, these bills propose to provide civil investigative demand authority to DOJ, change the penalties that can be imposed for noncompliance, repeal or modify exemptions to FARA, modify the administration of FARA by DOJ, amend FARA registration and disclosure requirements and public access to documents, alter the requirements for labeling of informational materials, restrict certain former federal officials, including members of Congress, from acting as foreign agents, and require reporting to Congress and the DOJ on FARA implementation, administration, and enforcement. In closing, the Foreign Agents Registration Act is more than 80 years old and primarily focuses on foreign agents engaged in advocacy activities in the United States. The congressional proposals recently introduced to amend FARA include a range of options. CRS is available to discuss these provisions further. Thank you again for the opportunity to testify. I look forward to your questions.
Thank you, Doctor. Our next witness will be Mr. Dylan Heitler Gaudet. He is the Government Affairs Manager at the Project on Government Oversight. In this role, he advocates for more accountable and transparent federal government through advancement of good government policy reforms. He focuses on issues ranging from lobbying and ethics reform to judicial accountability and congressional oversight. He received his MS degree from Northeastern University and his BA from the University of Southern Maine. Mr. Heitler Gaudet, you are recognized for 5 minutes.
Thank you, Chairman Cohen, Ranking Member Johnson, and members of the committee. My name is Dylan Heitler Gaudet, and I am the Government Affairs Manager at the Project on Government Oversight, and I'm privileged to be here with you today. I want to first start by commending the committee for holding a hearing on the Foreign Agent Registration Act and ways to improve it. Making much needed and long overdue reforms to this law will not only help the federal government keep a closer eye on the activities of foreign lobbyists and those who advocate on behalf of foreign interests, but it will also demonstrate to the American people that nobody is above the law, which includes politically well-connected K Street operatives. Shining a bright light onto the sources and activities of foreign lobbying is essential to protecting the integrity of U.S. political and policy-making processes. The Foreign Agent Registration Act is designed to do just this by requiring robust disclosure and reporting requirements on the part of those who advocate on behalf of foreign interests. We as a nation have been concerned with the potentially corrupting impact of undue foreign influence in domestic affairs since the dawn of the Republic, and today is no different, with the exception of the fact that today's foreign actors have ever more access to more sophisticated and more effective ways of influencing and shaping U.S. policy toward their own ends, which includes having access to a willing cottage industry of mercenary lobbying firms and influence peddlers. There are a number of flaws in the Foreign Agent Registration Act framework, and I want to highlight just a couple of them with you today, and I'd like to offer some proposals. I would encourage the committee to refer to my written testimony as well as to a supplemental report I have attached to that testimony to see a more complete range of proposals. First and foremost, the Department of Justice has not and continues to not sufficiently prioritize the enforcement and administration of this law. Back in 2014, the Project on Government Oversight published a comprehensive report in which we laid out a wide number of issues with the Foreign Agent Registration Act. One of our key findings was a systemic pattern of lax enforcement and an overall lack of interest at the highest levels of leadership at the Department of Justice. In 2016, the Inspector General of the Department of Justice had its own report in which they found very similar things. Unfortunately, not much has changed in the intervening years. One way to remedy this problem is to create a dedicated, standalone office that is responsible for enforcing and administering the Foreign Agent Registration Act. Right now, those responsibilities are in the hands of an under-resourced subcomponent within the National Security Division, and this simply isn't working. One other issue we see with the Foreign Agent Registration Act is registration itself. There are a large number of people operating here in DC who should be registered under the Foreign Agent Registration Act, but they aren't. One of the key reasons for this is the existence of a large loophole, the Lda Exemption. The Lda Exemption allows lobbyists who should otherwise be registered under FORA to avoid doing so by simply registering under the far less restrictive Lobbying Disclosure Act. One key way Congress can strengthen the law is by closing this loophole. One other issue we see with the Foreign Agent Registration Act is its over-reliance on criminal prosecution as the primary enforcement mechanism. We are encouraging Congress to create civil monetary penalties as another option in the toolbox that will enhance enforcement of this law at the Department of Justice. Lastly, I want to raise the issue of the outdated and anachronistic way that the Department of Justice makes available to the public the documents and materials that are filed by registrants. We are 22 years into the 21st century, and it's long overdue for the Department of Justice to overhaul and modernize the way it makes these materials available to the public, which must include adherence to and compliance with the latest guidelines and standards related to digital accessibility. Since I began my testimony with bedrock principles, I want to end in the same way.
You have a full minute to go.
What's that?
About a minute left.
1 minute left or 5 minutes done? Okay. Okay. Since I began my testimony with bedrock principles, I want to end that way too. We must strengthen the Foreign Agent Registration Act because there are weaknesses in the law that undercut its primary purpose, which is to shed light on the activities of foreign agents. We must also strengthen the law because it is critical to demonstrate to the American people that the rule of law is real and that nobody is above the law, and that includes the wealthy, the well-connected, and the powerful. Thank you for inviting me to testify today, and I look forward to answering your questions.
Thank you, sir. Our next witness is Jonathan Turley. He is the Maurice C. Shapiro and J.B. Professor of Public Interest Law, Director of the Environmental Law Advocacy Center, Executive Director, Project for Older Prisoners at GW Law School. written more than 36 academic articles that have appeared in a variety of leading journals, law journals, served as counsel in several notable cases over the last 2 decades. He has served as a consultant on Homeland Security and constitutional issues, a frequent witness before this committee and others in the House and the Senate, particularly on tort reform legislation. Receives a JD from Northwestern, not Northeastern, and his BA from the University of Chicago. You're recognized for 5 minutes.
Thank you, Chairman Cohen, Ranking Member Johnson, members of the subcommittee. It's a great honor to appear before you today to talk about the reforms on FARA. It's also a particular honor to appear with my esteemed fellow witnesses. I have tremendous respect for all 3 of these witnesses. I commend the majority in calling them here today. We have a great deal of shared views in terms of FARA, its possible reforms, and also its potential dangers that Chairman Nadler discussed earlier. I come to this as someone from the free speech community that has a rather robust view of free speech. I've been called a free speech purist. That used to be a compliment. But I have a certain resistance to registration systems because of the dangers that Chairman Nadler aptly laid out. FARA, for that reason, has been a subject of great concern in the civil liberties community for a long time. The concern is not with the degree of prosecutions. The degree of prosecutions remain relatively low. The concern is that it can be used to secure warrants, conduct searches, seize material, including confidential material, under a statute that is ambiguously worded and also, in my view, inconsistently applied. As the members of this committee know, FARA has been replicated in some countries like Russia, which cite to our own law as a justification for their crackdown on NGOs, journalists, and dissenters. That level of abuse is capable in any country, including our own. Indeed, FARA has been used for abusive applications in the past. We should not forget that FARA was created in the 1930s as something of an anti-free speech measure. The motivations were good. It was intended to combat fascist propaganda, but it was designed to stigmatize people that had views that were called un-American. That type of origin obviously raises a lasting concern among the civil liberties community. Now, in terms of its actual use, as has already been pointed out, it has been rather modest. Indeed, even in World War II, we only had a couple dozen figures that were prosecuted. We only had 8 individuals that were prosecuted between 1966 and 2015. On the civil enforcement side, we only had 17. That has gone largely dormant since then. But we've had an uptick, a shift towards criminal prosecutions. That is what concerns me about the changing of FARA. We're sort of in the 3rd incarnation of this statute. And I would encourage the committee not to go back to its origins in terms of a speech control mechanism, a way of stigmatizing what is viewed as un-American speech, even if that is done under the guise of disinformation. If it is transparency that is being sought in lobbying, you can achieve that with some, I think, well-reasoned reforms. In 1966, in the sort of 2nd incarnation of the Act, the Congress sort of moved towards that transparency model. And for that reason, I've suggested 4 areas that, in my view, would warrant clarification. That includes, this may seem rather trite, but it includes clarifying the purpose of FARA. It is not clear what the purpose is. We need to understand, if this is the 3rd incarnation, what FARA's purpose is today. I also suggest clarifying the line between criminal and civil enforcement. The Department of Justice has laid out sweeping discretion. That's a difference between 5 years in prison and a retroactive registering under the Act. It's considerable, and the Congress should look at it. I've suggested clarifying key terms that I believe are, as some of my colleagues have noted, ambiguous and dangerous. And finally, I specifically raised the clarifying of the legal exemption. It is still an exemption that is heavily laden with these terms that can have wildly different applications between different cases. But my greatest concern I started with and I will end with. I hope this Congress does not return to the original purpose of FARA and does not return to the use of the statute to combat un-American statements or viewpoints. There has been an array of statutes passed since 1938 that allows Congress to return to a more civil administrative approach to FARA. But there is no political agenda that you will see among the witnesses today. We are in agreement on many of these points, and I echo the chairman's view. I think that is a wonderful opportunity for us to come together on this statute.
Thank you, Professor Turley. Final witness is Mr. Nicholas Robinson. He's a senior legal advisor at the International Center for Not-for-Profit Law, where he manages the organization's U.S. program. Not-for-profit law, that means you don't have to do billable hours, I guess. That's good. That's good. His research and expertise centers on how laws aimed at curtailing foreign influence can impact civil society organizations, the regulation of the freedom of assembly, and civic space in a time of rising global authoritarianism. His research has been published in a number of academic journals, including the Duke Law Journal, but not the UNC Law Journal, or the Kansas Law Journal, and the Cornell Law Review. And he's regularly quoted and cited in leading news outlets. Prior to joining this group, he was a lecturer and fellow at Yale University, where he taught both human rights and professional responsibility. He's a postdoctoral fellow at Harvard Law School, and so he doesn't play favorites. Before that, he worked in India, where he was a clerk at the Indian Supreme Court, a professor at the Jindal Global Law School, and a senior fellow at the Center for Policy Research. Received his JD from Yale and BA from the University of Chicago. Mr. Robinson, you're recognized for 5 minutes. You don't go to anything but the best schools.
Good morning, Chairman Cohen and Ranking Member Johnson and members of the subcommittee. My name is Nick Robinson. I'm a senior legal advisor at the International Center for Not-for-Profit Law, where we work to create an appropriate legal environment for nonprofits in the U.S. and around the world. Today, I want to highlight why the Foreign Agent Registration Act needs to be better targeted. After the 2016 presidential election, there was an understandable increase in concern about Russian and Chinese influence in U.S. politics. In response, some policymakers, including the Justice Department, turned to FARA as a potential answer. And to be clear, renewed focus on the act has provided needed transparency around lobbying by foreign governments and has led to important prosecutions. However, as enforcement has ramped up, FARA's notoriously sweeping provisions have also increasingly interfered with the operations of nonprofits, businesses, religious institutions, and others with limited or no connection to a foreign government and in a manner that Congress never intended. Civil society has been raising the alarm. Consider a recent open letter to the Justice Department signed by the ACLU, Americans for Prosperity, the NRDC, and other prominent nonprofits. It warns that, quote, FARA's overbreadth and vagueness can undermine and chill First Amendment rights to speech and association, and the statute has a history of being used to target undesirable expressive conduct. While the department has in recent decades prioritized enforcement of the act against lobbyists of foreign governments, the act's provisions capture a dizzying array of other Americans. For example, a U.S. nonprofit that arranges a public speaking event in Chicago at the request of a visiting Ukrainian pro-democracy advocate would arguably be required to register under the act. Nor are these concerns merely hypothetical. As the Justice Department has ramped up enforcement, it has demanded that a U.S. church register for printing out banners at the request of foreign congregants who came to Washington, D.C. for the March for Life rally, or the Justice Department required the National Wildlife Federation to register because it accepted money from the Norwegian government to work with U.S. multinational corporations on improving sustainability of product supply chains in certain tropical countries. FARA's overbreadth provides the Justice Department the power to decide who will and will not be a foreign agent, a stigmatizing label that carries extensive reporting requirements and other burdens. Such power is ripe for abuse. For example, during the McCarthy era, the Justice Department used FARA to prosecute W.E.B. Du Bois, the renowned civil rights leader, for disseminating anti-war literature from a French nonprofit. This overbreadth and vagueness also creates confusion about who needs to register. As I sometimes joke with colleagues, FARA has become a job creation scheme for high-end DC law firms. While some can afford such expert counsel, most cannot. Importantly, having such a broadly worded act undercuts the Justice Department's ability to enforce it. Currently, the department is distracted by registrants who are not their enforcement priority, and they face the real prospect of the act being challenged on First Amendment grounds, undermining their ability to enforce it against anyone. I would respectfully urge Congress to take action. While there are many proposals to strengthen enforcement of the act, as my colleague from POGO described, and as Professor Turley also emphasized, the act, though, needs to be better targeted. This should include 3 key pillars. First, fix the foreign principal definition. Currently, the Act's foreign principal definition makes no distinction whether one is an agent of the Chinese government or one's grandmother in Canada. This simply does not make sense. Second, clarify the agency definition. One can currently become an agent under the Act by acting at the quote-unquote request of a foreign principal. However, if I asked 10 different FARA experts what request means, they would give me 10 different answers. Third, better target the Act's covered activities. FARA has had success in making visible the lobbying of foreign governments, but its other benefits have been far less clear. Congress should review the broad, often outdated set of activities that FARA currently covers to make sure that they are tailored to the purpose Congress is trying to accomplish with the Act. Thank you for inviting me today, and I'd be happy to answer any of your questions.
Thank you, Mr. Robinson. Just curious, the lady behind, who are you and who do you represent? You don't work with Mr. Robinson? Oh, because she was nodding the whole time, and I assumed she was part of your team. I wasn't sure. I just didn't know if you were getting good ratings or just had to end of whatever it was. I appreciate your testimony and how we can improve FARA. This is the questioning portion of our program where I have 5 minutes and we'll go down the line. Yeah, exactly. Do you think we should even have FARA? Do you think it should be, I mean, you don't have a great perspective on it. Do you think it's out, what maybe wasn't appropriate even in 1938, 39, but do we need FARA at all?
I think this is the question that Congress should be asking.
I am.
Yeah, and Congress as a collective body asking. And, you know, as I said, you know, it's been used most recently for providing transparency around lobbyists for foreign governments. And, you know, there is some distinctions from the LDA. The LDA could potentially be used in this way, or the LDA could be amended. But I think what's ironic here is when FARA was passed in 1938, they didn't have lobbyists in mind. There weren't really lobbyists in Washington, D.C. in the same way. And so it's really just not tailored, it's not targeted to purpose. And that's what it's used to. Most people can agree today, or many people on both sides of the aisle think it should be used for lobbyists of foreign governments. But beyond that, it breaks down, and there's many other tools and mechanisms that have been enacted since to target, say, you know, outside election interference or you know, other issues like that of concerns around foreign influence.
My friend, Mr. Johnson, brought up several Republicans who were involved in prosecutions. Mr. Greg Craig was too, a Democrat. Was his, and he went to trial, et cetera, but were there errors or areas where maybe he shouldn't have been? Did it go too far in getting Mr. Craig, do you think?
So I'm not an expert on that case, so I don't feel comfortable talking to that case, but maybe one of my
Thank you.
witnesses could hear.
I want to go. Well, Professor Turley, do you have any opinion on Mr. Craig's prosecution?
Well, that's one of those cases. I was concerned with a lot of the cases during that period because, as I say in my testimony, if you take a look at the legal exemption, but not just under the Act itself, but more importantly, obviously, the exemption defined by the Department of Justice, it is extremely ambiguous as to when you trip that wire. And I think the Craig case shows that what happened with him could have been applied to others. You notice that there was also an investigation of John Podesta. He was allowed to retroactively register. And when that happened, I have to tell you, I was looking at those cases going, well, All right, what's the distinction here? What's the clear distinction? Attorneys need to have some clear line, and I want to echo what Mr. Robinson said. It's not just attorneys. Nobody really cares about us in terms of being put in a tough position, but this is impacting public interest organizations who also have to make this decision. When you have the National Wildlife Federation told that they have to register as a foreign agent because they're advocating against the burning of the rainforest, it should be an alarm for Congress to say, look, we need to look at this as to where these lines are and have some consistent, coherent approach to who has to register.
Thank you, Professor Turley. Mr. Hetler-Gaudet, you have heard Mr. Robinson's discussion about LDAs. What's your response to those who argue that LDA registration provides sufficient transparency for the subset of agents of foreign principals that it covers because they don't represent foreign governments or political parties?
The short answer is no. I do not believe that the LDA has sufficient transparency safeguards and protocols in there relative to what we should expect of foreign agents or people lobbying on behalf of foreign interests. I think it is perfectly appropriate to have two different systems for people who are lobbying purely domestically and those who are lobbying on behalf of foreign interests, and that is in many ways the system we have now. I agree with my colleagues, though, that there is always, I think it's always a good heuristic in policymaking to be as clear and targeted and tight as possible, especially around key terms here in the Foreign Agent Registration Act. But I would not say that we should simply funnel foreign agents into the LDA's framework, because the LDA framework also has quite a few shortcomings and weaknesses. So I would, as I said in my testimony, and I elaborate a little bit in my written testimony, I would advocate that we actually close the Lda exemption and require all foreign lobbyists to register under the FARA framework, because it has much stronger reporting and transparency and disclosure mechanisms in there, and I think that's appropriate. That's as it should be.
Thank you, sir, and I'll now yield to Mr. Johnson, the ranking member.
Thank you, Mr. Chairman. Thank you all for the witnesses. Very much appreciate your expertise. Mr. Turley, I appreciated your testimony about the threats of Foreign Agents Registration Act being enforced as it may have been originally intended. Many of you mentioned that. In your written statement, you noted, quote, FARA began in the 1930s to combat propaganda and was framed as a way to curtail un-American speech. And when I read that, I must say that my first thought went directly to Judge Ketanji Brown Jackson. If un-American speech was still unlawful today, I'll just note here, there is no way she could be considered as a nominee for the U.S. Supreme Court. I mean, if you didn't see over the weekend, she testified in her post-hearing written questions for the record, quote, I do not hold a position on whether individuals possess natural rights. It's unbelievable. I mean, we can hardly imagine a more un-American position than denying the first self-evident truth of America listed in the Declaration. But I think she's the first SCOTUS nominee to openly hold such a position, but I digress. Okay, Mr. Turley, as I noted earlier, during Special Counsel Robert Mueller's probe, there were at least 5 indictments of conservatives under FARA, and that represents nearly as many FARA prosecutions in just 18 months as there were in the previous 40 years combined. And it would seem these alleged FARA violations were used as either a pretext to investigate those with ties to President Trump, or that FARA charges were used to pressure conservative aides in a bid to find a connection between the Trump campaign and Russia. So no improper connection on the president's part was ever found, obviously, and now everybody knows that was all just a complete sham. But here's the question. Based on your research into the issue and your understanding of the history of FARA, is it fair to say that the law became a highly weaponized tool of the DOJ and FBI against the Trump campaign?
Well, I do think that the Mueller investigation used FARA, as many prosecutors do, as a cudgel to go after some of these individuals. It's a very handy tool. It's sort of like 18 U.S.C. 1001. If you allege a false statement, you get into a warrant, you are able to do a search, you're able to secure information. But particularly with FARA, the concern is that at least with 18 U.S.C. 1001, you have to establish a false statement, and that was involved in the Michael Flynn case. With FARA, these terms are really difficult to track in terms of how they're being interpreted. The Department of Justice itself has withdrawn advisory opinions that, well, at least one critical one, as to the definition of some of these terms. And so suddenly what was interesting about the Mueller investigation is that many of us were familiar with FARA, but suddenly all the lights went on. It seemed like we went from a dead stop to you could throw a stick and hit a FARA violation on every corner in the city. And what really should focus the attention of Congress is not necessarily a questioning of Mueller's investigation, but the consistency of the application of the law and why suddenly we had this emphasis placed on the criminalization and the prosecution under FARA. I have to say that was quite a change from what preceded it. Before that happened, FARA was widely known in Washington as largely administrative process, and the penalty was usually retroactive registration, like what happened with John Podesta.
Right. Okay, so let me get to Hunter Biden. Now, have you had a chance to review the documents contained in that laptop, or at least the publicly available reports on those documents?
I have.
And as the statute currently stands, do you believe that Hunter Biden's activities on behalf of foreign interests, as evidenced by the documents on the laptop, required him to register under FARA?
What I think I feel comfortable in saying is I don't want to presuppose anyone's guilt.
Sure.
I guess what I would feel comfortable in saying is that with Paul Manafort, if you take a look at what he pled guilty to in 2018, there's obviously very strong similarities in the type of activities that were described in that indictment and what we're seeing in the laptop, including the acknowledgement of the possible necessity of registering under FARA. So if you look at that indictment, that would be a strong basis. If I were his counsel, quite frankly, I'm a criminal defense attorney, I think most people in my position would tell him that we need to be prepared for a charge here if Manafort's is the
standard.
It's standard. But I have to say, all we have are these accounts. We don't know what was presented in the grand jury. My understanding is that Hunter Biden has given information to the U.S. attorney. So I don't think that we can say with any great certainty that these cases are identical or that a charge is forthcoming. What I am saying is that if you use the Manafort indictment, this does not look good for Mr. Biden.
We all look forward to reviewing that record. I yield back. I'm out of time.
Thank you, Mr. Johnson. First, I would like to have Mr. Hank Johnson take the chair temporarily. I've got some visitors, and I will recognize Mr. Nadler for 5 minutes.
Thank you, Mr. Chairman. Mr. Strauss, in 1938, Congress chose to structure FARA as a transparency and disclosure regime. While clearly concerned about the influence of foreign propaganda at the time, was Congress also concerned about potentially curbing First Amendment protected activities?
Thank you, Congressman. Sorry about that. So in my review of the record, or my recollection of the record, it was something that was discussed, but I would have to get back to you as to exactly where the discussion came down on the lines in that original passage of the law for 1938. But it certainly, based on my recollection of reading the congressional documents, was something that was discussed during the hearings.
Thank you. Mr. Hedler-Gaudet, if I pronounce your name correctly. In your testimony, you highlight that FARA's registration exemption for individuals and organizations registered under the Lobbying Disclosure Act is particularly problematic from public transparency perspective. Can you further explain why it's problematic and what action Congress should take to address it?
Yeah, thank you, Chairman Nadler. The Lobbying Disclosure Act is not a very strong transparency and disclosure framework for people who are engaged in lobbying activities. The Foreign Agent Registration Act is a much stronger mechanism in terms of the actual reporting it requires, what documents and materials that someone who registers has to provide, the timely manner in which they have to provide it. So my recommendation there is to close the loophole that allows people who should otherwise be registering as foreign agents, or we can call them something else if we'd like to, people lobbying on behalf of foreign interests. They should be lobbying under FARA because they are doing something that is distinctly different, that we have a different interest in, and they should not be allowed to register under the less restrictive Lobbying Disclosure Act. And I think part of the problem there is we need additional sunlight and transparency around what could be potential undue foreign influence, because at the end of the day, we have to ensure that American policy is first and foremost being made on behalf of American people. And that's That is the bedrock guiding principle here, the North Star, if you will, around why these are two separate categories of activity, two separate categories of individuals, and why they require two separate regulatory frameworks.
Thank you. Mr. Robinson, in your testimony, you noted that the definition of agent of a foreign principal is overbroad, in particular because of how it defines the agent-principal relationship. How does FARA's definition depart from how this relationship is commonly understood in American law, and why is this problematic for the nonprofit sector?
Thank you. That's right. So the agency definition is very vague in the law. It's not just vague to us. The Justice Department has issued now over 50 advisory opinions on the agency definition. You have to have kind of a high-end law firm to go through to try to make sense of it. One word that keeps on coming up in the FARA agency definition is if you act at the request, the quote-unquote request of a foreign principal, then you can be considered an agent of that foreign principal. Under normal agency definitions, it's at the direction and control with consent of both parties. And that's what you'd find in the restatement of agency and case law. And this creates a big problem. So for example, I was requested today to come to Congress and appear and talk before you. No one thinks that I'm acting as your agent today, right? Or if I request a meeting with one of your staffers, they're not acting as my agent, right? But you see this all the time in the nonprofit sector where, say, an organization that works in child trafficking, one of their partners abroad requests, right, that they maybe host a meeting.
I hope you mean against child trafficking.
What?
I hope you mean against child trafficking.
Yeah, against child trafficking. Yeah, thank you for combating child trafficking. That if they ask to request to have help set up a public meeting in the U.S. or to distribute some literature, or they can be covered by the act. And this has just created a lot of confusion and uncertainty in the nonprofit community. I don't think the Justice Department is trying to go after the Amnesty Internationals of the world, but the act as it's written can clearly capture some of the behavior that nonprofits frequently engage in.
Thank you very much. I yield back.
Thank you. The gentleman from Maryland, Mr. Raskin, is recognized for 5 minutes.
Mr. Chairman, thank you very much. Before I get into FARA, I think that fairness compels me to answer my friend Mr. Johnson's amazing drive-by slam on Judge Jackson for stating the obvious, that she will enforce the Constitution and the Bill of Rights as written and not invent whatever rights she wants under the rubric of natural rights or natural law, two phrases which do not appear in our Constitution or in federal law. Other than Justice Thomas, who ended up having to backtrack from this position, I'm not aware of a single Supreme Court justice who thinks that a judge's personal interpretation of natural rights or natural law should inform his or her interpretation of the Constitution of the United States. And it was, in fact, the great conservative hero, Robert Bork, who vehemently opposed this idea of even trying to import natural law or natural rights through 14th Amendment due process or through the 9th Amendment. So I think Mr. Johnson may owe Judge Jackson an apology for what he's just said. We put justice on the Supreme Court to enforce the Constitution of the United States and the laws of the land, not their own airy notions of natural law or natural right. And I would urge him to rethink that whole thing. On FARA, I'd like to come to Mr. Robinson, and I want to go back to something you said about the potentially vast coverage of this statute. If I've got a lot of constituents who are Ukrainian Americans, and if they talk to Ukrainian family who urge them to come to Congress because of Putin's slaughter in their country, and to urge us in Congress to support the Ukrainian people with jets, for example, or anti-aircraft missiles, would they arguably be covered under FARA such that they would have to register?
Yes, I think this is the concern that under both the language of the act and also recent interpretation by the Justice Department, because they've been interpreting that word request so broadly, that they're covered under the language of the act, and that's just a serious problem. And it also came up, I think, when former military personnel from who served with folks in Afghanistan when they were trying to flee the Taliban were making similar kinds of requests to Congress, and they could also easily get caught up in the language of FARA as well.
Well, as a nation of immigrants where people do have family and friends all over the world, I think that is, a deeply problematic and ludicrous implication of an existing federal law. On the other hand, would you agree that if Vladimir Putin wants to employ people from his multi-million-dollar internet research agency to work to pump propaganda into the American system, say to promote his pro-Russian views, and pays people to do that, either working on internet messages or working on influencing TV celebrities like Tucker Carlson, that people who are directly on the payroll or receiving consultant money from a foreign government, people like that should have to register?
Yeah, no, so I think this is the question. The way that we've been advocating is to define foreign principal as foreign government or political party or those operating on their behalf, and to redefine the agency direction to a definition to make it much more acting at the direction and control. So that type of situation. So I think those are the types of situation where FARA could apply.
Go ahead. And the reason, the analogy I want to draw is to our campaign finance laws, where we don't allow Vladimir Putin or President Xi or Orban or any of the authoritarians around the world or any political parties or governments around the world to put money into our political system, right. Period. They're banned. And at the very least, if they're paying people to come and lobby here or to disseminate propaganda, disinformation in our society, we should know about it. That should be exposed. Do you have any problem with that idea?
No, I think that's right. I think the challenge on the propaganda side is how do you distinguish kind of the BBCs of the world from the RTTVs from the world? And right now, FARA doesn't do a good job of that. And I think that's
yeah, but why do you need to distinguish if BBC is actually paying people to work as reporters here? That should be disclosed.
Right.
What's the
and I think right
that?
now the FCC has just adopted regulations requiring that kind of disclosure. And so I think the question is, what tool should Congress be using for that disclosure?
The gentleman's time has expired.
Thank you, Mr. Chairman.
I'll now go to the gentlewoman from North Carolina, Ms. Ross, for 5 minutes.
Thank you very much, Mr. Chairman, and thank you for being in the room to help out our subcommittee. I also want to thank all of the panelists for joining us today. The Foreign Agents Registration Act is an important tool used to combat foreign influence in the United States. The law promotes government transparency by requiring certain foreign agents of foreign principals who are engaged in political activities to publicly disclose their relationship with foreign principals. The law does not prohibit attempts by agents of a foreign principal to shape political discourse in the United States, but is intended to shed light on who is engaged in such efforts on behalf of foreign principals. By doing so, FARA promotes transparency in the policymaking process by allowing the public to consider the source and the allegiance of the messenger when evaluating the message. This committee has not held a hearing on FARA since 1991, when the world's geopolitical and technological landscape was dramatically different than it is today. There is bipartisan interest in reforming the law to enhance its transparency mechanisms. It's time that we considered new proposals to modify the law in order to strengthen its impact and ensure that it is serving its intended purpose. My first question is for Mr. Hetler-Gaudet. The effectiveness of FARA is ultimately premised on the notion that shedding light on the activities of certain agents of a foreign principal seeking to influence the United States will make the government more accountable to the American public. But based on your organization's research, are the registration statements, supplements, and informational materials filed with the Justice Department accurate, timely filed, and easily accessible to the public?
Thank you, Congresswoman. I think in response to your question, I think the short answer is no, comma, not really. The Department of Justice has come a long way in recent years, though as a quick anecdote, back when we published our report in 2014, a couple of our staff members, they spent just about every day at the FARA unit, which by the way was only open between 12 and 4 each day. They spent every day there trying to comb through documents that had been filed by FARA registrants. And at the time, this was 2012, we're talking only 10 years ago, not that long ago, the FARA unit didn't even have a scanner, so it could not make these things that had been filed with the FARA unit, it could not have them in electronic format, which I think just tells you about the lack of sort of emphasis and prioritization and lack of resources around enforcement. Now, things have changed a little bit since then, and they have gotten a little bit better. They are not yet where they need to be. I mentioned in my opening statement that we are 22 years into the 21st century, but the Department of Justice, at least in the FARA context, has not caught up and not even come close to catching up. They need to standardize. They need to standardize, and they need to harmonize the way things are filed, the way things are posted, the way things are made available to people like me. By the way, I'm blind, in case y'all didn't know, so I have to use a screen reader in order to read things on the computer. But if you are simply scanning a physical document, all you're scanning is an image. A screen reader cannot read an image. So what you have is you have a whole crop of people, blind folks and others, completely locked out of the process of being able to access these documents. And that's just a small example of how the Department of Justice has not caught up to modern standards around this kind of thing. And that hurts and undermines public accessibility broadly. So that is a long way of answering your question, Congresswoman, saying we are in need of a comprehensive overhaul and modernization effort at the Department of Justice when it comes to these documents and making them actually transparent and available to the public.
And is there anything specific that Congress can do? Or do you think this is merely just oversight of what an administrative agency does?
Yes, I think, unfortunately, and this is not specific to the Department of Justice, this is true across the federal government and all agencies, without prodding and without being required to do so, they will not do things to make their informational materials more accessible, and they won't do it proactively. So I think Congress is in a position where you all have to force the issue in some way here. We've seen that it's taken this long to get to where we are, and where we are is not sufficient. But without congressional action, I fear we'll still be waiting another 10 years for the Department of Justice to catch up to where it needs to be.
The gentlelady's time has expired.
Thank you so much, and I yield back.
I thank the gentlelady. I'll now recognize myself for 5 minutes. Thank you to the witnesses for your appearances today. Always great to see you, Professor Turley. I'll start with you with my questions. Since we've been talking, or you guys have been talking about the Hunter Biden laptop controversy, you did have an opportunity to read the Washington Post articles about the laptop. Is that correct?
Yes, sir.
And you would not disagree with me that the Post article found that the verifiable emails on the hard drive were just a small fraction of the data on the hard drive. Is that correct?
Yes, sir.
And the vast majority of the data could not be verified that was on the hard drive. Isn't that correct?
I'm not too sure if that's correct with regard to the grand jury.
I'll take judicial notice myself of the fact that it was a part of the story. And sloppy handling of the hard drive was one of the reasons why they could not verify the vast majority of the data. And they found, isn't it correct that they found that data was repeatedly accessed and copied by people other than Hunter Biden over a 3-year period?
Yeah, I'm not too sure if that's been clearly established. I think that,
Well, that's what, again, the article reports. I don't think there's anything that would refute that at this time. But bottom line, though, even in the 129,000 emails or however many it was that could be verified as authentic on the Hunter Biden hard drive, not a scintilla of evidence of criminal wrongdoing has been talked about today by my friends on the other side of the aisle. Isn't that correct?
well, I'm not too sure what's been discussed, but in terms of criminality, I think there are legitimate questions in the laptop.
And so the FBI has the laptop and is looking at those, including whether or not Hunter Biden should have registered as a foreign agent. And so thank you, Professor Turley. Mr. Hetler, Mr. Robinson, FARA contains several exemptions to the registration for agents of a foreign principal engaged in certain activities which are specified under 22 U.S.C. 613, correct?
That's correct.
And what are some of the examples of these exempted activities?
So probably the most frequently cited exemption is for private and non-political activities for bona fide trade or commerce. And this is a really important exemption, the commercial exemption, because the Act actually requires registration if you distribute anything of value in the United States on the behalf of a foreign principal. So if there wasn't this exemption, it would, stop almost all, cross-border activity, commercial activity. But there's not a similar exemption for nonprofits. So there's a host of exemption or a set of exemptions, but unfortunately they don't capture very common activity by both nonprofits and the public at large.
So you believe that the exemptions are not adequate to address current realities?
That's correct.
Have you seen any evidence that Hunter Biden unlawfully failed to register as a foreign agent in the laptop contents?
I have not seen the laptop contents.
Just fishing, I guess.
You're blessed.
Pardon me, I'm sorry. How would you respond to those who may argue that the need to disclose foreign influence on U.S. policymaking outweighs the burdens to nonprofits that you've outlined here today?
Well, I think you can have both in the sense that the Act needs to be better targeted, right? Where we're talking, I don't think anyone's questioning, that, a lobbyist for the Saudi government or the Chinese government should need to register or have some sort of disclosure. The problem is when it starts catching up, congregants at churches who are printing out banners for March for Life rallies or for climate change rallies. And that's the situation we're in right now. So the Act needs to be much better targeted to fulfill the purpose.
Thank you. Mr. Hedler-Gaudet, you stated in your written testimony that strengthening FARA helps to secure the rule of law. What do you mean by that?
Thank you, Chairman Johnson. What I mean by that is when we see so few FARA violations being I don't want to say prosecuted because we have concerns about overuse of criminal prosecution, but when we see so few people who violate this law being held accountable in a meaningful way, what that does is it sends a message, and it not only sends a message, but it actualizes the message that laws are not necessarily always laws, and not everyone is held accountable to those laws in an even-handed way. And that fundamentally undermines the rule of law. The rule of law is predicated on the idea that we are all subject to them, and we are all subject to them because to use a term that is particularly applicable, here justice is supposed to be blind, and if we are unevenly and selectively applying laws, including this law, then we are not delivering on the promise of the rule of law in a rule of law society.
Thank you. My time has expired. Well, we'll now move to the gentlelady from Texas, Representative Jackson Lee, for 5 minutes.
And to the witnesses, I appreciate very much the testimony that you have given here today. Let me thank and specifically pose questions to Professor Turley. First of all, I think we have been seeing each other any number of years as you've come before this committee, and your scholarship is well respected. We have come to a point that is so different from when I came here, that the divide now is so intense that we use laws to try to probe divisively. This seems to draw some moment of conclusion, but of conclusion of the unity behind the fact that there is a purpose in trying to deal with the foreign agents registration. Can you go back again, just very briefly, to its origins of speech, and then I would pose a question of how do we protect against that now, and then secondarily, my friends on the other side seem to be consumed with the son of the president. And I would hope that you would respond that that should not be the purpose of this legislation, to pull and condemn and indict individuals. That should not be the point of our reform, because this is going to be a lasting legacy, if you will, of reform. So let me pose that question to you.
Thank you, Congresswoman. It's wonderful to see you again. Yeah, I believe that you framed the question exactly right in terms of the origins of FARA. It did begin as a tool to stigmatize speech that was deemed as un-American. And that is a legacy of this act that I hope Congress will not return to. As has been already noted, there's a public interest in transparency, and it's hard to argue against that. But it's also important to remember that since 1938, we have a lot of new laws, not particularly new, we have a lot of laws since that time that force transparency. You don't need FARA to get transparency in higher education or in elections. You don't need it in most proceedings where, for example, when I came here today, I was asked to identify any foreign interests that I might represent. So I think that this is a really important time to reevaluate what we're trying to achieve in FARA and possibly sort of reframe it to achieve whatever those purposes are. And I certainly agree with you, Congresswoman, that we should not be viewing this as a weapon to use against political opponents. This is a very powerful law, and it can do great harm. And you only have to look at what Russia has done, and they point to us. They point to our law and say that they modeled their FARA on what we do. And we have to be aware of that this is something that can be easily used for the worst purposes.
I like that framework. My time is running, but let me, Mr. Hedler Godet, let me try to suggest that we're in different times. We have social media. We are sometimes getting such politicizing of propaganda with Russia, and let me put on every record that I am before of my disdain for Vladimir Putin in terms of the murderous behavior and terrorist behavior that he's engaging in, and of course perpetrating lies about Ukraine and what is going on to the Russian people and really around the world. But with social media joining in some instances who happen to support that, do we need additional definitions, because this is such an ancient law, if you will, to update, because some of that behavior may be the behavior of a foreign agent that is trying to impact the people in the United States?
Thank you, Congresswoman. And I think, yes, we do need to update. As has been pointed out many times today, this law dates back to 1938 and hasn't been substantially reformed since 1995. And a lot of things have changed since then, including, as you point out, the advent of social media. And I want to pause to flag that there has been an effort right here in the House of Representatives. There was a bipartisan bill led by Representatives Spanberger and Representative Katko that would do just this. It would try to contemplate social media content and try to construct the sort of framework around it that we need to reflect modern day realities, including that it needs to be conspicuously labeled as being on behalf of a foreign agent, if it is in fact that. I think you're absolutely correct that we do need to update the Foreign Agent Registration Act framework around what kind of content is an informational material, and if it should be reported and labeled as such.
If anyone quickly wants to answer it, I know the gentleman's indulgence, all right? Indulgence has just gabbled me, but I'd like others to provide answers in writing. I appreciate that very much if they cannot provide it at this time. I thank you, Mr. Chairman, and I do yield back.
I thank the gentlelady. And this concludes today's hearing. I want to thank all of the witnesses for appearing today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. With that, the hearing is adjourned.